The logic of this panel is that I thought we'd like to pursue the whole question, which is, I think, dear to the hearts of many, and no one would ever deny that the community and others in the Canadian society are interested in bringing to justice war criminals living in Canada. However, the situation is that such an experience of investigation is already being carried out in the United States, and I thought it might be wise to perhaps look at the American experience, but first have some type of discussion about how people feel about this in Canada before the Deschênes Committee actually is met and in fact carried out its own investigation. So this is why the Canadian perspectives maybe a little bit logically comes first, and I'd like to ask the foremost defender of the position of the necessity for prosecuting war criminals in Canada, Mr. David Matas. It's an honor for us to have him here. His time, of course, is in great demand as chairman for the League for Human Rights, B'nai B'rith Canada. Mr. Matas.
Thank you. Thank you very much for inviting me. You've now heard some 8 speakers, and I guess you're going to hear 8 more. I congratulate you for coming here in such numbers and for staying here. I don't know whether any of us can be described as good speakers, but I can say of every one of you that you're all good listeners. Now, I'm not a historian and I'm not an academic. I'm a lawyer in private practice in Winnipeg, and I wanted to bring a legal and human rights perspective to the issue that's before you now. Canada has begun a belated attempt to come to grips with the problem of Nazi war criminals in our midst. For 40 years, we've done virtually nothing. There's been only one extradition, that of Albert Helmut Rauka, extradited in 1983, just 2 years ago. There have been no denaturalizations. There have been no deportations. There were 7 Canadian prosecutions in Germany, in occupied Germany, when the Canadian troops were there, immediately after the war, but there have been none in Canada. Now we're coming up against a deadline. Soon, all the witnesses, all the surviving victims, all the perpetrators will be dead. Soon it'll be too late. If justice is to be done, it must be done quickly. Now, there's been some comments that were made by Saul Littman and Simon Wiesenthal that aroused a lot of concern within the Ukrainian community in Canada, and I wanted to refer to those comments and then refer to the concern and then react to the concern. Simon Wiesenthal said that he believed 218 former Ukrainian officers of Hitler's SS, which ran death camps in Europe, are living in Canada. Saul Littman, a Canadian spokesman for the Simon Wiesenthal Center, said that records prove that 28 Nazi war criminal suspects in Canada belong to Ukrainian SS units. Now, those were the statements that generated concern, and I suppose this meeting here today is part of it. There was a press conference that was called earlier by spokesman for the Ukrainian-Canadian community. John Nawasad, president of the Ukrainian-Canadian community, stated the allegations reflect badly on Ukrainians and people of Ukrainian descent born in Canada. Orest Rudzer, past president of the committee, stated many Canadians are under the impression that all Ukrainians collaborated with the SS. The leaders emphasized they wanted to see war criminals brought to justice, but they expressed fear of a witch hunt reminiscent of the McCarthy era. The matter was also raised in the House of Commons by a couple of members of Parliament. Alex Kindy, the Member of Parliament for Calgary East, urged that efforts to bring war criminals to justice not be allowed to reflect poorly on entire ethnic groups, such as the Ukrainian-Canadian community. Don Blenckern, the Member of Parliament for Mississauga South, has expressed a similar concern, this time about Canadians of German descent. He claimed that, in an effort to assure the world we do not harbor war criminals, it has seemed to some that the government is out to castigate the German people. He urged that justice is not advanced by revival of memories of torture, injustice, and old bitterness. He asserted that Canada has an obligation not to suggest that Canadians of German descent are war criminals. Now, I believe that these fears of a witch hunt need not be realized. We must indeed be careful that ethnic slurs are not used when bringing Nazi war criminals to justice. Normally, when criminals are prosecuted, they are not identified by their ethnic origin in the normal criminal courts, and they should not be identified in that way here. The Professor Zumbakis, or Mr. Zumbakis, in a press conference we had earlier, said that it would have been better for Wallace, who was going through proceedings in the United States, to be referred to as a Polish national rather than a Nazi. Well, certainly he shouldn't have been referred to as a Nazi until such time as he was found described, because that presumes he's guilty before the proceedings take place. But I think it's also improper to refer to a person by his ethnic origin as well. We should not, however, be so fearful that ethnic slurs might arise that we do nothing about bringing Nazi war criminals in Canada to justice. After all, the prosecution of a war criminal is not a prosecution of the people to which he belongs. It is a prosecution of the individual alone. When we prosecute criminals for other crimes, we do not normally consider the prosecution a slur or an attack on his community, and there's no reason why that should be so here. The notion that war crimes were individual crimes with individual guilt is the very antithesis of the notion of collective guilt. It is the notion of collective guilt, not individual guilt, that is an incitement to hatred. The Jewish community, which has been pressing for action to bring Nazi war criminals in Canada to justice, would be the last community to want to inflict collective guilt on others. The Jewish community has been the victim of collective guilt for millennia, for the death of Christ. It was only in 1961, 24 years ago, that the World Council of Churches resolved that Christians should repudiate the idea of the collective guilt of the Jews for the crucifixion of Christ. It was only in 1965, only 20 years ago, that the Roman Catholic Church declared in the Second Vatican Council that what happened to Jesus Christ should not be charged against all the Jews without distinction, then alive, nor against the Jews of today. Taken in its extreme form, the fear of linkage between ethnic slurs and the Holocaust, the Nazi murder of 11 million innocent civilians and prisoners of war, including 6 million Jews, and the attempt to exterminate the whole Jewish people, has led to Holocaust denial. Witnesses in the Zundel trial, which just finished, have testified how they felt better about being German once they believed Zundel's claims that the Holocaust never happened. I suggest that an appropriate response to Holocaust denial is not just to inform people about the existence of the Holocaust. We must also reject the linkage between the existence of the Holocaust and the perception of attack on the Germans or any other people. We should approach this matter, I suggest, neither as ethnic Jews or ethnic Russians or ethnic Germans or ethnic Ukrainians. We should approach the matter simply as Canadians, concerned that the innocent go free and the guilty are punished, concerned that there not be murderers in our midst, concerned that Canada not be a haven for war criminals. My own belief is if we have that attitude, we cannot go wrong. I want to take issue with one remark that I quoted Mr. Blenckern having made, that justice is not advanced by the revival of memories of torture, injustice, and old bitterness. I disagree, and I suppose by the fact that you're here in such numbers and that this event is being staged, you would disagree as well. I feel that it is important we not forget what happened. I say that justice is denied by repression of memories of torture and injustice. For one thing, we owe it to the victims. We cannot remember the victims by forgetting their murderers. Bringing their murderers to justice is a small attempt to salvage something from the meaninglessness of their deaths. As well, we are faced today with the acute problem of Holocaust denial, as the Zundel trial illustrates. Forgetting about the Holocaust and not reviving its memory is a direct aid to those who would have us believe it never existed. There is, in addition, this regrettable fact. The Nazi Holocaust was not unique, as we found out today. History is replete with tragedy. And I can mention, for instance, the Soviet forced famine in the Ukraine in the 1930s, where millions died from starvation. Forgetting tragedy means forgetting history. Nor is the Holocaust just history. Today, we face the threat of a nuclear Holocaust, where not just one people faces extinction, but where the whole human race faces extinction. Jonathan Schell, in his book, The Fate of the Earth, wrote that Hitler's attempt to exterminate the Jewish people is the closest thing to a precursor of the extinction of the species that history contains. If we are to avoid the ultimate Holocaust, we must not forget the Nazi Holocaust. We can learn from it that insane crimes are not prevented from happening simply because they are unthinkable. On the contrary, they may be all the more likely to occur for that very reason. We can learn from it, to use Schell's words, of the gaping, unmendable holes in the fabric of the world such crimes cause. Though the Jewish people have survived, the Jewish shtetl culture of Europe has gone and will never be revived. The very difficulties we face in dealing with the crimes of the Nazi Holocaust after it happened can teach us the impossibility of dealing with a nuclear Holocaust after it happens. It can teach us that we must respond to the threat of the nuclear Holocaust before it is realized, or lose the chance to respond at all. Forgetting the Nazi Holocaust or pretending it did not exist is very much like forgetting about the threat of the nuclear Holocaust or pretending it does not exist. If we do that, we court disaster. We cannot face squarely the dangers that threaten us by forgetting the disasters we have suffered. I've written recently a report titled Bringing Nazi War Criminals in Canada to Justice, and I brought a copy along of it here, just in case I forget what I wrote. But the report was published by the League for Human Rights at B'nai B'rith. The report canvasses a range of legal options available for bringing Nazi war criminals in Canada to justice. I believe there are many, and the report goes into them in some detail. But I point out to you that up to now, the government has basically taken the position there are none, or very few, except maybe extradition to a Western European country. The previous speaker seemed to leave the impression that there's nothing been done because there isn't the evidence, and if there had been the evidence, something would have been done already. But the fact of the matter is that the government has taken the position that it was not legally possible to do anything. And that's why allegations have been left up in the air. That's why this report I wrote has been produced, and that's partly the reason why the Deschênes Commission was appointed. Now, the report is technical in nature. It does, however, have a basic and simple point to make, that the crime of murder should not go unpunished. Nazi war criminals in Canada should be brought to justice. Now, what the report is talking about is murder. It's not talking about collaboration. Collaboration with the enemy, serving in the German armed forces or for the German armed forces, is not in itself a war crime or a crime against humanity. It is only if there is murder of innocent civilians or prisoners of war, if we get involved in the crime of murder, that we're talking about war crimes or crimes against humanity. That's perhaps legally, for the lawyers amongst you, a little bit brief, but that's in summation correct. Canada has no statute of limitations for murder. The government of Canada asked the government of the Federal Republic of Germany to extend its statute of limitations at a time when the Federal Republic of Germany statute would have had the effect of barring prosecution in the Federal Republic of Nazi war criminals. Canada should not impose upon itself a statute of limitation for these murders. Nazi war criminals were able to enter Canada after World War II. The Jewish intended victims fleeing the Holocaust were denied entry by Canada before and during World War II. Canada internationally has said that the prosecution of war crimes and crimes against humanity constitutes a universal commitment for all states. It has maintained that position year after year at the United Nations from 1946 to the present. In 1981, at the General Assembly, Canada even proposed that position. Canada should do what it has committed itself at the United Nations to do. Canada must not say one thing abroad and do something else at home. Canada must respect all its basic principles of human rights when bringing Nazi war criminals in Canada to justice. Now, I know you're going to hear in a few minutes about the Office of Special Investigation in the United States. I attended a press conference at lunchtime where that was discussed amongst other things, and perhaps I could anticipate a few of the remarks you might hear by making some comments about the Office of Special Investigation. The I'm a Canadian lawyer and not an American lawyer, so I don't purport to be an expert on that, but one comment I have heard was that there's a disadvantage to the accused because of the imbalance that the state has, the advantages the state has in presenting its case. And I point out to you that that is an imbalance that exists in every criminal case, yet we consider our criminal justice system fair, and there's no reason why that imbalance should lead to unfairness in these prosecutions or deportations or whatever legal proceeding is taken. Secondly, there was a point raised about the damage that is done when somebody is accused and then found not guilty or found innocent of the charges. But I point out to you that I don't think we can expect a 100% success rate in prosecutions. We certainly do not have it in our ordinary criminal system. And what's more, there are countries with a 100% success rate in prosecutions. And we have, I think, good reason to question the independence of the prosecution from the court itself when there is a 100% success in prosecution. So I don't think the fact that there have been cases where innocent people have been charged in itself can itself be an indictment of what has happened in the United States. As I say, we must respect our human rights principles, but no human rights principle requires Nazi war criminals to go free. Canada would be violating human rights in the grossest way imaginable if it maintained the crime of murder must go unpunished. Now, there are three legal points I wish to address that may be of particular interest to the audience. One is the use to be made of Soviet-supplied evidence. The second is the defense of duress. And the third is the bringing to justice of other non-Nazi criminals against humanity. First, what is to be made of Soviet allegations, and what is to be done with Soviet-supplied evidence? I recently attended a meeting where I heard a spokesman for the Ukrainian-Canadian Committee ask this question. Should we not object to Russian interference in Canadian affairs when Russia gives to Canada a list of Ukrainian criminals, a list of witnesses, but does nothing about their own criminals? Now that question gives me some concern. One of the greatest achievements of the international human rights movement is acceptance of the principle that violations of human rights are not matters of internal domestic concern alone. They are matters of international concern. A government is not free to brutalize, to imprison arbitrarily, to torture, to terrorize, to murder its own population, free from international approach. The Soviets are quick to argue interference in internal affairs whenever the West raises human rights violations with the Soviet Union. If Canada were now to mimic Soviet rhetoric when the Soviets produced lists of Nazi war criminals or lists of witnesses, we would reinforce their claim to non-interference when we raise other human rights matters with them. Rather than reject the Soviet lists or the Soviet witnesses, we should examine seriously all the information the Soviets supply. We should use our own seriousness as an example to them when we raise our human rights concerns about Soviet violations. Because Canada has done virtually nothing about bringing Nazi war criminals in Canada to justice, because Canada has done nothing of a comprehensive nature, not only are the guilty not punished, as well the innocent are not truly free. We are left with speculation and a cloud of suspicion. If the Soviets make allegations, we should examine the allegations. If the Soviets have witnesses, we should examine and cross-examine the witnesses. Canada should make its own assessments using Canadian standards of justice. We should not do nothing about criminals in our midst because the Soviets do nothing about their criminals. Rather, we should act and use our own action as an argument for the Soviets bringing criminals in their midst to justice. Second, there's the question of duress. Now, there's a letter to the editor in the Winnipeg Free Press, which I quote here, and I'll just read a sentence. It talks about the Ukrainian officers who allegedly participated in running the death camps, and it says that the Gestapo used some individuals from local police forces to patrol barracks from the outside and to assist in the transportation of prisoners, but all of them served as ordinary robots in such situations. Now, duress is a defense under the Canadian Criminal Code. I'll read you out the code provision. It says, a person who commits an offense under compulsion by threats of immediate death or grievous bodily harm from a person who is present when the offense is committed is excused for committing the offense if he believes the threat will be carried out and if he is not a party to a conspiracy or association whereby he is subject to compulsion. The defense doesn't apply to a number of offenses. It doesn't apply to murder. It doesn't apply to attempted murder. but the courts have held that the defense does apply to aiding and abetting murder. The defense of duress is different from the defense of superior orders. By Canadian law as well as by international law, superior orders is not a defense. Whether the defense applies in a particular case depends upon the facts of the case. It is not a general defense that applies to all Nazi war criminals. The evidence in some cases has been that if a person did not want to work in the death camps or for the death camps, he would still have to work for the Nazis, but he would be transferred to another task. The evidence in other cases has been that the accused believed in the genocide that was taking place and participated enthusiastically. A person is not guilty of a war crime simply because of his nationality or ethnic origin. Neither is he necessarily innocent of all war crimes simply because of his nationality or ethnic origin. Only a functioning legal system where the facts are properly canvassed can sort out the innocent from the guilty. Now finally, the question of other crimes against humanity. The Nazi war crimes are not the only war crimes that have been committed, as we've heard here. The Nazi crimes against humanity are not the only crimes against humanity. What should Canada do about the other war criminals, about other criminals against humanity? Romos Vastakis, who's going to speak later, who's on the panel, has called for a reopening of the Nuremberg trials to bring to light atrocities committed by Soviet war criminals. And I won't say anything more about what he has said, because he can speak for himself. The Canadian War Crimes Act, which is one legal recourse by which Nazi war criminals in Canada could be brought to justice, is limited to wars in which Canada took part after September 9, 1939. It does not apply to crimes against humanity inflicted outside the context of war, like the Soviet forced famine in the 1930s inflicted on the Ukraine. It does not apply to war crimes in which Canada is not a part, like the Soviet invasion of Afghanistan. A few years ago, I proposed to the Canadian Bar Association a resolution that new legislation be passed to allow for prosecution for war crimes and crimes against humanity, whether or not committed during any war in which Canada has been or may be engaged. The resolution passed the Bar Association in 1981 and now represents the policy of the association. More recently, in my capacity as national chairman of the League for Human Rights of B'nai B'rith Canada, I proposed an amendment to Bill C-18, now before the House of Commons, to the same effect. Bill C-18 is sometimes referred to as the drunk driving bill, since it increases penalties for drunk driving. But what it does as well is add to the list of extraterritorial offenses already in the criminal code. It proposes adding to that list the offenses of hostage taking and theft of nuclear materials. And I had suggested adding 2 more extraterritorial offenses to the list: war crimes and crimes against humanity. This proposed amendment could have the effect as well of allowing civilian trials for war crimes. The War Crimes Act provides for military trials. The proposed amendment would prevent the raising of some technical objections that have been raised to the use of the War Crimes Act and also the Geneva Conventions Act, another legal avenue in our statute book. The Standing Committee on Justice and Legal Affairs has already made a ruling that it will refuse to hear witnesses on this proposal on the ground that it is not germane to the bill. It is an indication that the proposal itself will be ruled out of order. It's a ruling I, myself, would regret. It is not only Nazi war criminals that should be brought to justice. All war criminals, all criminals against humanity should be brought to justice. And I think we need to follow that principle, not only for the sake of justice, but also for the sake of credibility when bringing Nazi war criminals in Canada to justice. We need balance. We've got to avoid selective prosecution. We have to be comprehensive in our approach. I want to conclude by quoting Alexander Solzhenitsyn from the Gulag Archipelago about other criminals. In that book he wrote, and I quote, "When we neither punish nor reproach evildoers, we are not simply protecting their trivial old age. We are thereby ripping the foundations of justice from beneath new generations." I say to you, in Canada, there is a trial going on right now. It is not a trial of a Nazi war criminal. It is a trial of the Canadian justice system. If Canada is not to be left with a permanent stain on its justice system, we must act to bring Nazi war criminals in Canada to justice. Thank you very much.
May I simply add a further note to Mr. Mattis's point about collective responsibility. I have before me an outgoing press release from the Canadian Jewish Congress by Milton Harris, the president. I'd just like to read it to you very briefly. so that everyone is very clear where the Canadian Jewish Congress stands on this issue. In respect to recent press reports on individuals suspected Nazi mass murders in Canada, we reject allegations that any ethnic group be identified as culpable of genocide. Group liability will always be rejected by the Canadian Jewish community. The Canadian Jewish Congress has constantly stated that mass murderers residing in Canada should be brought to justice irrespective of national origin. Congress will aggressively pursue this objective.